Appeals on Wheels. Hosting such an esteemed event, this session of the court is very rare and it's a meaningful opportunity, and we are deeply grateful to Chief Justice Kemp and the Arkansas Supreme Court for choosing Fayetteville High School as today's site. I would also like to extend a special thank you to our honored guest, Dr. Mulford, Fayetteville Public Schools Superintendent, and Nika Weitzman, Fayetteville School Board President. And we have various community members and law school students that are here today as well, so we welcome all of them. Today, you have the unique privilege of witnessing the highest court in our state in action, engaging with our judicial process firsthand. Thank you all for joining us. We are very proud to host this event, and we look forward to the day of insightful learning and civic engagement. Please help me welcome our FHS choir to begin our day. Will everyone please stand as you're able as we sing our national anthem? All right, thank you to our FHS choir. This is a real court proceeding of the Arkansas Supreme Court called oral argument. It involves real people, serious subject matter, and there are rules that the audience must follow. The rules that are in place in the Arkansas Supreme Court courtroom in Little Rock will be in effect here today once the court is in session. The attorneys will have an opportunity to advocate for their clients, and the justices will ask attorneys questions about the case. When the justices are ready to begin, the bailiff will announce, "All rise." You are expected to stand if you are able. When you are instructed that you can be seated, you may be seated again. While the court is in session, please do not speak and please refrain from getting up. Also, while in session, there is no use of any electronic device by the audience. If you have a cell phone, recording device, or any other electronic device, please power it off once the court is in session. Please remain seated at the end of the proceeding and await further instructions. Thank you.
All rise. Hear ye, hear ye, hear ye. The Arkansas Supreme Court is now in session. All persons having business before this honorable court draw near, give attention, and ye shall be heard. May God save these United States, state of Arkansas, and this honorable court. You may be seated.
Good morning. On behalf of your Supreme Court, we want to thank the University of Arkansas School of Law and Fayetteville Public Schools for inviting the court to hold oral arguments here today. We want to express our appreciation to the Fayetteville High School staff for all your time and effort in arranging this event. Special thanks are given to Dr. Jonathan Mulford, Superintendent of Fayetteville Public Schools, Dr. Michelle Miller, Principal of the Fayetteville High School, and to the School Board of the Fayetteville Public Schools. Also Chief Mike Reynolds of the Fayetteville Police Department, and Sergeant Sean Allen, and all of the Fayetteville High School and District Resource Officers. Chef Richard Bell and the Fayetteville High School Brightwater Culinary students, thank you. Emily Godinini, the choir director, Leanne Gershner, music director, and the Fayetteville High School choir. Also Warren Rosner, the high school drama teacher, for the stage setup. We also want to express thanks to the ambassadors and justice escorts, Alexandria Couch, Lana Keithley, Blake Freeman, Jenna DeLafter, Isabella Lehman, Olivia Savage, Juan Gomez, and Claire Brandon. We also want to thank the clerk of our court, Kyle Burton, and deputy clerks Bobby Jackson and Chuck Munson. Thank you to Pete Hollingsworth, the Supreme Court Chief of Police, and also Officer John Mack of the Supreme Court Police. And a thank you to Danielle Cummings of the Arkansas Administrative Office of the Courts for coordinating this event for the court. Without the attorneys agreeing to argue this case in Fayetteville, we could not hold oral argument here. So the court wishes to thank the attorneys for their willingness to argue this case here. We welcome the students of Fayetteville Public Schools and High School here today who are attending the oral argument, and we express a special thanks to Dean Cindy Nance and the University of Arkansas School of Law for the invitation to conduct Appeals on Wheels in Fayetteville to commemorate the 100th anniversary of the law school. We enjoyed a reception yesterday evening at the law school hosted by the Arkansas Bar Association. And we look forward to lunch later today with students at the law school. And I want to acknowledge the law students who are in attendance today. Prior to the year 2000, the Supreme Court could not conduct court outside of Little Rock. With the passage of Amendment 80, the judicial article to our state constitution in 2000, the court can now conduct court outside of Little Rock. Since the passage of Amendment 80, the court has held court in all corners of the state, from Paragould to Bentonville, Texarkana to Monticello, and 30 towns in between. The court believes that it is very important to hold court in all parts of the state. It gives the opportunity for people to see the Supreme Court at work, because not everyone can go to Little Rock to observe their Supreme Court. This is a very valuable educational tool that gives more people the opportunity to better understand how their Supreme Court works and the role of the Supreme Court as a co-equal third branch of government. Several years ago, we began live streaming the Supreme Court's oral arguments. Now everyone anywhere with internet access can watch the court's oral argument. The oral arguments are archived, and you can watch the oral arguments at any time on our website. I would like to introduce the other justices of the court. To my right, Justice Karen Baker, who is from Clinton. She practiced law there, served as a public defender, was a circuit judge in Faulkner, Searcy, and Van Buren counties for 6 years, served as a judge on the Court of Appeals for 10 years, and has served for 14 years as a justice on your Supreme Court. And as of Tuesday, she was just elected as the first woman Chief Justice of the Arkansas Supreme Court, which she'll begin serving in January. Justice Rhonda Wood of Conway. Justice Wood practiced law in Conway, served as a circuit judge for Faulkner, Searcy, and Van Buren counties for 6 years, served for 2 years on the Court of Appeals, and has served for 10 years on your Supreme Court. Justice Barbara Webb of Benton. Justice Webb practiced law in Little Rock, served as prosecuting attorney for the circuit. She served as an administrative law judge with the Workers' Compensation Commission for 10 years. She was the first female circuit judge in Saline County. She served as chief administrative law judge for 2 years, and Justice Webb has served for 4 years on your Supreme Court. To my left, Justice Courtney Hudson of Harrison, now Fayetteville. Justice Hudson practiced law in Fayetteville, served as a law clerk for the Court of Appeals, served for 2 years on the Court of Appeals, and has served for 14 years as a justice on your Supreme Court. Justice Sean Womack of Mountain Home, now Springdale, or actually Tawnytown. Justice Womack practiced law in Mountain Home. He served as a state representative, a state senator, served 8 years as a circuit judge in Baxter, Boone, Marion, and Newton counties, and has served 8 years as a justice on your Supreme Court. Justice Cody Highland, formerly of Conway, now Little Rock. Justice Highland served as prosecuting attorney in Faulkner, Van Buren, and Searcy counties for 7 years. He was appointed and served as United States Attorney for the Eastern District of Arkansas and has served as Director of the Department of Public Safety. Justice Highland has served a year and a half on your Supreme Court. I'm Dan Kemp. I grew up and live in Mountain View. I practiced law in Mountain View and served as municipal judge there for 9 years. I served for 30 years as a circuit judge in Independence, Cleburne, Stone, Izard, and Fulton counties, and I've been serving as Chief Justice for 8 years. It's a custom of the court to allow a justice from the area in which we are having our oral argument for our appeals on wheels to address the assembly. So at this time, Justice Hudson, who lives in Fayetteville, will have an opportunity to address the assembly. Justice Hudson.
Thank you, Chief Justice. Fayetteville is my home, and it's been my home for over 30 years. I have raised 3 children here, and in fact, you may know my youngest son. He graduated from FHS in May. His name is Harrison Henry, and I am extremely grateful for the exceptional education that Fayetteville Public Schools have given my son, and after graduation, he accepted an appointment to the United States Naval Academy. I spoke with him last night on FaceTime. He was laying in his bunk at the Naval Academy and was asking me about today. He so much wanted to be here. The FOMO was palpable over FaceTime. And in our conversation, you could just feel it, how much affection he has for this institution and the people who make it happen. He asked me to give a few shout outs here. So here we go, some of his favorites. Coach Fife, thank you so much for the leadership that you provide and allowing students and student council to fill new roles. And Harrison, of course, mentioned Dr. Miller and Miss Lawson. He said, Mama, show them a lot of love, because he feels that way about you all. Miss Pinter, surely she is here. He said, Mama, she wouldn't miss it. She's AP Gov. I need to credit you with the default station, television station in my house now is YouTube archived Senate judiciary hearings. That's exciting. We don't watch movies. We watch judiciary hearings thanks to you. Good job, Ms. Pinter. Steve Jansky, the athletic director, you were a great guide to my son. Mr. Bill, I said, Harrison, do you think I'll actually see Mr. Bill? He said, no, Mama, he's going to be in the parking lot putting those awful yellow stickers on a third of the students' cars while we are in oral argument. And secret to you, Dr. Miller, I think the Chief Justice may have parked illegally. Sergeant Allen, last but not least, you and the resource officers here at the high school, throughout our school district, guys, they make our schools safe. And Harrison wanted me to especially thank Sergeant Allen for the many conversations that he got to have with him during his stay at Fayetteville High School, and is hoping that felony Fridays are not quite as often. So all in all, FHS, I've just hit the highlights. There are so many amazing people that make all things good happen here, and I am grateful. Our current Chief Justice, Dan Kemp, his term is coming to a close, and this is going to be our last opportunity to travel with him as Chief Justice, and we certainly appreciate his leadership and his service for the past 8 years. And I would also like to take an opportunity to congratulate my friend and colleague, our senior justice on the court, Karen Baker, for her election as the next Chief Justice, the Chief Justice-elect. Congratulations, Justice Baker. Thank you.
This is also an oral argument that's probably going to be the closest to Justice Womack's home. I doubt if we ever have a Appeals on Wheels in Tawnytown. So I'll give him an opportunity to make some remarks as well.
Well, thank you, Chief. And before I speak, I do want to echo what Justice Hudson said in terms of appreciation for the Chief's leadership over the last 8 years. We were both circuit judges together, and then we came on the court at the same time, and so this will be his last Appeals on Wheels, and so appreciate the work you've done in the last 8 years. But my hometown is Mountain Home, but my adopted home area is Northwest Arkansas. My wife, Melinda, is here today. I couldn't be in this job without her. She worked to put me through law school when we lived here in Fayetteville, and we always eventually wanted to get back here. Even though we don't live in Mountain Home anymore, that's still, kind of part of our home. Since I've been on the court, we haven't had an Appeals on Wheels there, but just before I got on the court, I had invited the previous court to come, and we got to do that, and we had Justice Scalia there. It was about a year before he passed away, and so that was a great opportunity. But since this is our adopted hometown, the Chief gave me a few minutes here, and we do love Northwest Arkansas and everything about it, the Razorbacks, the natural beauty here, and I also want to recognize I've got a couple other folks here. My family doesn't usually get to see what I do because we live up here and I work in Little Rock, but I've got my son Jordan here and my daughter Bailey and our new granddaughter Sayla, so I appreciate them being here and everything they do, and just thank you all for hosting us here in Fayetteville. You've got a beautiful facility, and we're happy to be here, and happy to be here with the law school this week as they celebrate their 100th anniversary.
Okay, thank you. When we finish oral argument, we'll be speaking with different groups about our judicial system. The court will hand down an opinion in this case approximately 4 weeks from now, and we hand out opinions within 4 weeks in about 75% of our cases that are submitted to us, which is the fastest turnaround time of any Supreme Court in the country. Again, thank you to the University of Arkansas Law School and to Fayetteville Public Schools for inviting us here and hosting this event. Will the clerk please read the submissions?
There is one appeal for oral argument this morning. It is case number CR-24-263, Kevon Turner versus State of Arkansas from Pulaski County Circuit Court. In addition to this appeal, there are 14 various other motions and petitions being submitted to the court today. More information about these submissions is available at the judiciary website and by contacting the clerk's office.
Okay, thank you. This time we'll take up our case for oral argument today, which is Turner v. State, CR-24-263. And the court will acknowledge and recognize the appellant's attorney. Mr. Kaiser.
May it please the court. And a big thank you to the Fayetteville High School students, faculty, staff, and greater community for being here. Thank you so much for your interest. My name is Michael Kaiser of the Lassiter and Casanelli Law Firm in Little Rock, and I stand here before you today proudly representing the appellant Kevon Turner in this matter. There was insufficient circumstantial evidence that Kevon Turner was an accomplice to the capital murders at issue. The jury had to resort to speculation and conjecture, speculation heaped on conjecture, inferences on top of inferences to convict, and his convictions must be reversed and dismissed accordingly. Alternatively, the trial court abused its discretion by permitting the state to introduce testimony about a lately disclosed Snapchat message purportedly sent by Mr. Turner to a state's witness, despite the state not doing anything to even attempt to recover the actual message or the fact that a message was sent at all. Either way, this court must reverse Mr. Turner's convictions. I will stand on the briefing as to the voir dire issue unless the justices have any questions for me. On April 26 of 2021, Joe Cortland Robertson, Martez Holmes, and a third unknown individual who was not Kevon Turner approached Roderick Shelby's car parked at the Greens apartment complex in North Little Rock and fired into it multiple times from multiple weapons, shooting Shelby and his passenger Andrea Verser multiple times, killing both. The evidence against Roberson and Holmes was strong, undeniable even. For Roberson, there was eye testimony witness from a friend and a neighbor, Calvin Bibbs, identifying Joe Cortland Robertson as one of the shooters. Mr. Bibbs testified that he saw Mr. Robertson standing over and taking something from Mr. Shelby's dead body, recognized Mr. Roberson's SUV by the color, make, and model, and saw that he ran to that car at the time of the shooting. Cell site location information placed Mr. Roberson at the apartment complex at the moment of the murders, a place he did not live at. Video surveillance showed his car entering the parking lot moments before the murders. Mr. Roberson pleaded guilty to his involvement in the murders. Mr. Holmes, similarly, cell site location information placed him at the scene of this crime, a place he did not live. He also pleaded guilty for his involvement in the case. And the evidence against these two, they were dead to rights. It is not surprising why they made plea deals here. But by contrast, the evidence against Kevon Turner was scant and legally insufficient to prove his involvement in these offenses. The evidence showed that Kevon Turner was a resident at the Greens apartment complex, so his presence there means nothing as it does for the other two. The evidence showed Turner was friends with Mr. Shelby, and it went all the way back to their days at the Whitehall High School. He was described by Mr. Shelby's father as a very respectful young man.
Mr. Kaiser?
Yes, ma'am.
You're not contending that just because Mr. Turner wasn't the trigger man, that he couldn't have been an accomplice here. Is that correct?
That's correct.
All right. So regardless of how guilty the other two looked and the fact that they pled guilty, that does not necessarily affect the analysis here that we have about your client.
No, Your Honor, it does not necessarily mean he is not guilty. That is correct. The evidence showed that Mr. Turner actually called the decedent, Mr. Shelby's father, the day after the charged act and was crying, gave his condolences. Mr. Shelby Sr. testified about, asked Turner if he would be willing to speak with a police officer, a detective, and he said yes. And ultimately he did, multiple times.
Mr. Kaiser, it seems like some of the most damning evidence is the fact that there were cell phone calls going back and forth between your client and Roberson, a multitude of them. What, has it ever been your contention that in those conversations that Mr. Turner was trying to dissuade Roberson Holmes from moving forward with the murder?
Your Honor, because of the state's lack of proof, we don't know. So the state introduced the facts that calls had been made at specific times in the duration, but due to the technology we have, could not produce what occurred on those calls. The state did not introduce any text messages between these people or anything to say specifically what they were discussing. The state's evidence made clear that this was a group of people who was frequently in contact with one another. Mr. Turner and Mr. Shelby, the evidence showed, were engaged in some sort of fraudulent, COVID-based unemployment scam together, as well as dealing drugs. The decedent had calls with Mr. Roberson. Mr. Roberson had calls with Mr. Turner. Mr. Turner had calls with Mr. Shelby. What we don't know is what occurred on those calls. And that is the speculation that the jury had to make to reach a guilty verdict here.
Well, in fact, there were over a dozen calls in the hours before the shooting between Turner and Roberson. Is that not correct?
Justice Womack, I don't remember the specific number, but that sounds right, about a dozen.
And then Turner denied even knowing Roberson.
Yes, so there was testimony that at his second interview with police about a month after the crime, Mr. Turner denied knowing Mr. Roberson. Yes.
And counsel, he also fled the state after being interviewed by the police after the murder, and our case law says that the jury's able to sort of take presumptions of guilt from that. Is that correct?
Justice Wood, I would agree. Our case law certainly allows post-incident conduct to be weighed in the sufficiency for the conduct itself. I would take umbrage with the word fled. The evidence showed that he was arrested, I believe, in Dallas, Texas, definitely in Texas. There was no such evidence that he fled a pending charge, just that he was arrested there.
Counsel, so he was charged with capital murder, which it was in relation to committing a homicide and in furtherance sort of a robbery, the underlying robbery. When you were talking about the other two that pled guilty, sort of the shooter and his sort of, I guess, other accomplice, you were saying that the evidence was sort of dead to right in a sense, and that someone saw them bending over and taking something off the deceased body. And so does that mean that you're sort of conceding the robbery, the underlying robbery in this capital murder crime in relation to Turner then? Because in your brief, it seemed like you were saying there wasn't sufficient evidence of a robbery, but from what I heard at the start, it sounds like you're conceding that now.
Your Honor, I'm conceding that those two committed murder. I'm not conceding robbery. I am noting that the testimony from Mr. Bibbs was that I think Mr. Roberson or Mr. Holmes appeared to be grabbing something, but there was no evidence adduced as to what was taken, if anything was.
So, but if they pled guilty and you're sort of conceding that they committed a robbery, if this court believes that he was sort of accomplice in the sense of participating because of the phone calls and the other circumstantial evidence, then it would be sort of logical to follow that he was participating in the robbery, underlying robbery as well. Would you agree?
Justice Wood, I don't follow. I apologize.
That's okay. I guess if he's participating in one crime that's committed, then he's participating in both.
I would agree with that. If the court finds sufficient evidence for the underlying offense as an accomplice, then he's guilty of the capital murder. Yes, ma'am. Of course.
Mr. Kaiser, can we, I know we're limited on time, can we turn to your other point on appeal regarding the Snapchat?
Yes, please.
The disappearing message and your claim of the lack of evidence on there. Oksana Pavlov testified that she informed Turner about the police questioning and that he had instructed her to withhold evidence regarding the gun. Apparently that was done over Snapchat, and it was likened to a telephone call. I guess you made a best evidence argument. It was likened to a telephone call. If he had told her that information, if he had instructed her orally over the phone versus sending a message that is designed to disappear, contrast those issues for our analysis. with the evidence of the Snapchat?
Yes, Justice Womack. So the original here, I guess the problem is, what is the original when we're dealing with an electronic message as opposed to a written communication or a single phone call? And so the case that we cited in our 5-1J notice, the case from the Army Grindstaff, notes that one of the originals may have been on Miss Pavlov's phone. But what about Mr. Turner's phone? What about the records with Snap, the company that operates Snapchat? So we're asking the court to follow the analysis of that admittedly unpublished Army Court of Appeals opinion, finding that there was not proof that the original or all originals were lost. So I guess what we're asking the court to do is to look at electronic messaging in a unique way compared to a hard copy message, kind of the way this court does with cell phone warrants and numerous other things where we have added protections for electronic messages.
Counsel, who has the burden? So if, this is a first impression issue, so for us our court with Snapchat, so if, we all know Snapchat disappears unless you immediately hit the sort of save button. If that's sort of common knowledge of that, and is it become the defense's burden to sort of combat that, or are you asking us to sort of set the standard that the state has the burden to show they tried to reach out to Snapchat and obtain it within the sort of 90 days or whatever that is, and that it wasn't available, that would be the standard, sort of that they couldn't comply with best evidence, and so that's why the testimony? Or is it the defense's sort of burden? I mean, who's the burden?
So I guess we're not asking the court to place the burden on the defense or the state, but on the proponent of the evidence. And the state cited a secondary source from 2015, almost a decade ago, which is a bit outdated when dealing with a modern technology, but even that publication confirmed that these records are recoverable from the phone itself, from Snap. It's the company that owns Snapchat. And we cited the Snapchat Law Enforcement Guide, which makes abundantly clear that at the very least, the fact that a communication occurred between one person and another and what time it occurred is discoverable, as well as likely, but we don't know because the state never attempted, the record itself. So while the state put on mountains of cell site location information after obtaining search warrants and getting it from the cell providers for 3 different people that formed a large part of the evidentiary basis in this case, they neglected to do so in the exact same manner with Snapchat. And so we are asking the court to find that the original was not lost and that the state did not show it was unavailable by process because they didn't even attempt to.
Well, the communication, finding that a message went back and forth is not sort of as much relevant to what was in the message about the gun. But we know whether or not she told law enforcement about the Snapchat message within the sort of period that you could recover that message from Snapchat itself?
Your Honor, I'm not familiar with a specific period that it can be recovered. I know the Law Enforcement Guide mentions 90 days, but even the state's third or secondary source notes that it can be recovered from a phone even years later, and that was 9 years ago. So again, we don't know because the state never tried, despite doing the same with every other person's cell phone here. For whatever reason, they did not do that with the Snapchat message.
But counsel, didn't the defendant basically testify that, it was his friend that testified that he called her and through Snapchat and told her not to mention anything about the gun, which was .40 caliber, which he admitted to owning a .40 caliber weapon, and which when he told the police he would bring the weapon in, and then he went out of state and the weapon was never turned into the police. So I think when you consider all that evidence, does that not build the credibility of the fact that, and when our case law, our prior case law allows a telephone call conversation to come in, we haven't held people to the burden of proving that the call existed. They can testify to the contents of that call. So how do you distinguish those cases and those facts from your argument?
Well, Your Honor, first, I would just note that, this is part of our argument that the jury had to rely on speculation to convict. The court is saying that the gun mentioned in the Snapchat message must be one of the murder weapons and must be the same weapon that Mr. Turner discussed with law enforcement in this case, but there's actually no proof of that. He said, please don't, excuse, I don't think he used the word please, but he said, don't talk about a gun. So even on this point, the jury had to rely on conjecture to find that that gun was the murder weapon or even the gun that Mr. Turner was talking about.
But Mr. Kaiser, how relevant is that, given that the state's not alleging that he was the shooter, but that he was an accomplice?
Well, I mean, the state, it's very relevant given the way the state argued at a trial that this was the gun that was used despite no proof of such, and they pointed to that message. And I know the state is arguing that the Snapchat message was cumulative to other evidence, that Turner discussing his specific .40 cal weapon with Detective Gibbons means that this evidence was cumulative, but it wasn't. They're very different things. Turner discussing a weapon he formerly had that he didn't turn into the police is not the same as him allegedly tampering with a witness and telling her what to say and what not to say to police, which this court has found can be evidence of consciousness of guilt. So they're qualitatively different. The prejudice from this Snapchat message was huge. The state focused on it heavily throughout their closing argument and ultimately got a capital murder conviction in a circumstantial case. Justices, I see I've gone well over my time. I'm going to probably ask for a little less rebuttal time next time, but if there are no further questions at this point, I will reserve my remaining 4 minutes for rebuttal. Thank you.
Okay, Happily.
Good morning, Chief Justice, Associate Justices, if it may please the court. My name is David Eanes, Assistant Attorney General, here representing the state in its response to Kevon Turner's direct appeal of his 2 capital murder convictions, capital felony murder convictions, which have, being due to felony murder, have an underlying felony offense of aggravated robbery. And that is...
Mr. Eanes, let me interrupt you for just a moment. Our clock did not start. Just notify the clerk. Okay, go ahead.
Thank you, Your Honor. I didn't notice that. So that's admitted here. There's no dispute that there were 2 capital felony murders convicted on April 26, 2021.
Counselor, if you don't mind, let's just pick up where we left off with Mr. Kaiser about the Snapchat argument.
Absolutely, Your Honor.
I'm curious, why did the state not try to subpoena Snap to see if, in fact, this message could be recovered? Because Mr. Kaiser makes a good point. The state did know how to go about seeking cell phone records, time, place of calls in regards to Roberson, Turner, Shelby.
And if I may start by, there was a question earlier of my colleague. It is in the record at the transcript 307 in the initial suppression hearing involving Oksana Pavlov. It is undisputed that this Snapchat message was not disclosed to law enforcement until about a month before the trial. This incident happened in April of 2021. The trial happened in November of 2023. So there is established proof in the record that law enforcement never knew about this for more than 2 years. The state met its burden, Justice Hudson, here. The only testimony, evidence in the record about the qualities of Snapchat was by Ms. Pavlov. And she testified that this was a snap, a photo that disappeared instantly upon being viewed. There was some argument among counsel about where else it might exist, but there's absolutely no evidence in the record, and certainly the defense didn't put on any witnesses or evidence that a quote-unquote original, and this is however much I've split hairs with my colleague about whether it was a writing or a photograph. actually.
Well, but I think what Mr. Kaiser was saying is that the proponent of the evidence, in regard to the best evidence rule, should be the one who has the burden to come forward and tie that neatly in a bow for us.
And the state met its burden. It put on a witness that established that the original had been lost, and there was no other evidence to the contrary, and my colleague has not presented a case from the state of Arkansas on the best evidence rule that says that the state had any further burden to do that. The state, albeit Court of Appeals cases, has cited, as the court has observed, the Snapchat cases are, even though it's been around for more than a decade, are rare nationally and also
Well,
in
and then
Arkansas.
possibly that's why Mr. Kaiser couldn't find one, is we haven't had an opportunity to speak to this.
That's possible. And counsel did cite an unpublished military court case this morning, and if the court has a chance to drill down on that, or already has, I would like to talk about Grindstaff for a moment. It's distinguishable. There's two unpublished cases here, extra-jurisdictional, one that was cited in the state's brief, and then Grindstaff that was cited this morning. Grindstaff is distinguishable. If the court drills down on that, you will see that, one, it was subject to military rules, court-martial rules, and military rules of evidence that don't necessarily quite match up with Arkansas's rules. And one of those rules, and really what's distinguishable here, is that under 703A, a rule of courts martial that was newly enacted in 2019, and counsel hasn't argued that there's anything in Arkansas that matches that. The real dispute here in that case was that the the government, in this case, the federal government, did not subpoena and had a positive duty to subpoena anything it was aware of. In Grindstaff, it's undisputed that law enforcement knew in the sexual assault case about the Snapchat within 24 hours. And I'll speak to why that's important if I have time here in a moment. So really and there was also a failure to disclose. And the essence of Grindstaff is the court, the military court, scolded the government, called them negligent on the discovery issues. But in the end, the lay witness who saw the Snapchat video, not the victim, testified about it, and it was accepted that it was destroyed and no longer available. And I'd also like to point out another issue I'll speak about in this case. Ultimately, that court, as well as the Michigan Court of Appeals in the unpublished case cited by the state, determined that there was no prejudice, that the evidence was so overwhelming that it didn't matter if there was any error committed, that there was no prejudice.
So on that point, and I understand the distinction with the military rules and our rules, but you're making the case on the Michigan case that the evidence was so overwhelming. This is more of a circumstantial type case here. So given that this is kind of a first impression issue and dealing with this best evidence rule on these disappearing messages, I get you didn't have the information for 2 years, but you had it a month before trial. Could there not have been some effort made either to, in that month before trial, subpoena the information and get that, or request a continuance based on that that information?
Well, again, no, Your Honor, in a direct answer. And again, the only evidence and testimony that was able to be considered by the circuit court below about the qualities of Snapchat and its self-destructing qualities was gone. The snap was gone upon viewing, unless she took a screenshot. But the trick of that was Kevon Turner, the murderer, would have instantly got a message that his friend had saved the "don't tell anyone about the gun" snap.
Well, it was gone as to Ms. Pavlov's phone, but I think Mr. Kaiser's point is it was still discoverable somewhere else, either on Mr. Turner's phone or by getting the information from the company.
Two things on that. On Mr. Turner's phone, which is a new issue, on whether or not it was discoverable on Mr. Turner's phone, I would note that under Rule of Evidence 1008, I believe, if Mr. Turner believed he had an original, under 1008, he had a duty to produce that if he didn't want the contents to come into the record otherwise. On the evidence, the speculation that something existed, which has only been supported of late in appellant's reply brief in a corporate document that allegedly was pulled off of Google, a 2024 legal process document. So if you look at that, even within that document that my colleague has submitted to the court late in the day, it says that the qualities of Snapchat are updated and change all the time, and you need to refer to their website to find those qualities. Also, if the court chooses to consider that new document that was submitted in the reply, that corporate document, Snapchat itself says on pages 7, 8, 15 that snaps, the photographs, disappear instantly upon viewing, just like...
Counsel, isn't part of the problem here is that after the fact, so after the trial, you're giving this court all this information about how Snapchat works and how photos, you know, if you don't save it instantly, it disappears and everything. But at the moment of trial, when you're sitting in front of the court, all the state put on was the girlfriend of the defendant in a capital murder trial who was there the night at the apartment, admittedly, you know, doing drugs, going back and forth, riding in the car with the defendant, obviously knew about a gun that she wasn't supposed to tell cops about, you know, and it's her on the stand that you're saying could establish how Snapchat works for the court, whether or not anything could be saved, whether or not if she saved it, the other side would get notice of it, whether or not, you know, that's why she saved it or not. She didn't testify, I didn't do that because I was worried about him getting notice of it. She just didn't do it. But that was what the state put on. The state didn't put on, hey, here's what happened timing-wise. It was too late for us to know. They didn't, and go find from Snapchat. The state didn't put on, here's how Snapchat works from any kind of expert in technology and in the process. So that's enough. Any witness, you know, that probably isn't the most legitimate witness can get on and testify as to technology and why I don't have it anymore. And that's what you're telling the court?
Yes. I think under the existing case law, the state met its burden by putting on the only witness. No one disputed that she, at least as a late witness, had a valid opinion. She testified that Snapchat was the app that was used, the primary means of communication between she and Mr. Turner. And I see that the court's uncomfortable with this, and it is a relatively new subject, and certainly it's.
And counsel, I'll say, if, you know, to say, you know, the court's uncomfortable, you know, whether this defendant's guilty or not, but he's on trial for, you know, and has a life sentence. So it's, you know, important about whether a significant piece of evidence is legitimate and how the technology works, and whether anyone off the street can take the witness stand and talk and say, this is how the technology works. You know, we all may know, but, you know, that's what you're asking us to create the standard.
There are a few cases, Your Honor, answering that out there that deal, I mean, this rule we're applying last time it was amended in 1997 rule to social media. Many of the cases that deal with best evidence rule, the few that are out there in Arkansas precedent, deal with things like the contents of wills or letters. So the cases are far and few between. We've cited 2 Court of Appeals cases, Dillard, the 2020 case, we've got 2 Dillard cases, and then Campbell, both of which it wasn't Snapchat, but the evidence from a lay witness was text or emails or voicemails were destroyed. That was accepted. No one had to bring in an expert or subpoena anyone to see if it was stored elsewhere. The cases that are cited in a footnote by my colleague don't deal with that issue. And, and the state met its burden through that lay witness of testifying that it was destroyed. However, even if the court finds there was some error here, I'd like to speak to the standard very quickly. It's a course of abuse of discretion. The court's aware of that, which means even if the court erred and it's given discretion in its evidentiary rulings, it had to not just commit an error, but improvidently, thoughtlessly, or render that ruling without due consideration. That's obviously not the case here. There were multiple hearings. Additionally, the other element, opposite the hand in hand with the abuse of discretion, is that there had to be some harm or prejudice, and there clearly wasn't for 2 reasons. and I think it was mentioned by the court earlier, Ms. Pavlov was the next to last witness to testify in this trial. Well prior to that, the police detective who interviewed Mr. Turner himself testified that Mr. Turner told him he had a .40 caliber handgun. In the course of that conversation, as the police detective drilled down on that, he asked him reasonably if they could produce it for testing to clear Mr. Turner, or perhaps as inculpatory evidence. We don't know. Mr. Turner at first denied that he had shot anyone or he'd shot a gun, but as they talked about this, the police detective testified in that interview that Mr. Turner, he asked him to turn it over, and then Mr. Turner's story changes. He says, well, I don't have it anymore. I gave it to somebody. But if I can get it back, I'll turn it over. Of course, that never happened. We also have consistently Roderick Shelby Sr., the father of the victim's testimony, that he too asked Mr. Turner to turn over the weapon. Mr. Turner said he would. Never happened. The testimony by both of those witnesses occurred well prior to Ms. Pavlov's testimony about the Snapchat message about the gun. And the state's theory in all of that was consciousness of guilt. And the fact that he didn't turn it over when he was requested to, he didn't have a duty to, but he agreed that he would. It never happened, and that equally is consciousness of guilt. Plus the Snapchat aside, as my colleague characterizes it, the frequent contact in this case was overwhelming. The dozen phone calls, most of which the court can take notice from the record, happened in the 15 minutes before these murders and then immediately after, the 15 minutes
But
after.
Counselor, we don't know the content of those. And I mean, is it speculation? Is it conjecture? Was Mr. Turner trying to dissuade these men from moving forward possibly with the crime? We just simply don't know what was it happened during those conversations.
The state would submit there's no other reasonable explanation than the one that the jury came up with, that he participated and facilitated this. We do, by the way, know the contents of one of the telephone calls, one of the earlier ones from Mr. Turner himself, when he called Ms. Verser and Mr. Shelby multiple times to see when they were going to arrive back home from dinner. Of course, because Ms. Verser told Mr. Turner that Mr. Shelby was maybe drunker from dinner. Mr. Turner offered to help them get out of the car when they got to the apartment complex if they would call him, and there were multiple calls about that. Of course, the couple sat in their car for 15 minutes before they were murdered, and Mr. Turner, never showed up. And of course, there was one pocket dial, I think, but all the calls by Mr. Turner to Mr. Shelby occurred before the murders. He did not ever, we know this from the videos, which by the way were time dated and matched, the court's aware, with the phone calls. So we know that Mr. Turner never went to that car, never checked on his friends, even though they sat there for 15 minutes, never went to his apartment. But what he did do was, in the wake of the murders, have, as his friend tried to exit the parking lot, having heard the gunshots, instead he directed her to drive straight. Well, straight was straight past the body. He recognized, Ms. Pavlov testified, he recognized the body of Mr. Shelby laying there in the parking lot where he died from 22 gunshot wounds. And what did he do? He asked her to stop. He got out of the car and walked past his friend and partner in crime's body without looking, without checking, without anything else. And then shortly thereafter, after the North Little Rock police arrived at this apartment, he came back and stood feet away from his dead friend's body that he knew was laying there and asked the police officer. The police officer's testimony was about his friend and the location. Beyond that, the overwhelming evidence, again, we have all the videos, security videos all over this apartment complex that were undisputed about who was there. We have the parking lot meeting. The only time there weren't phone calls in the 15 minutes and the before and after the murders was one, during approximately 3 minutes. We know from the video that it took Mr. Turner and the 3 masked gunmen to have a parking lot meeting within minutes of those 3 masked gunmen then going straight to the car. There's no other evidence that Mr. Roberson would have known that 15 minutes after they arrived, they were still sitting in the car. The gunman went straight there, surrounded it, fired into it. No calls during those few minutes, but immediately after, Turner and Robertson are on the phone together. Defense counsel, when commenting on this, could have been the phone, we didn't know what the phone calls were about, suggested that it was maybe they were exchanging pie recipes. That was the reasonable hypothesis here. We know during that parking lot meeting, during the murders, and then about 15 minutes after the murders, when the masked shooters ran back to their car and it wouldn't start, and then immediately ran in the direction of Mr. Turner's apartment behind it. I see that my time is just about up. I would like to, so in light of the overwhelming evidence here, the Snapchat, if it was an error, was harmless. I would also like to speak to voir dire real quick, just to note that if it wasn't decided, if the issue of whether or not restricting voir dire of the jury about sentencing, whether or not that wasn't resolved by Dillard and Nelson, it was definitively resolved by the 51J, excuse me, a letter that was sent to the court earlier this week about an opinion that was issued on Thursday that's practically on all fours in a capital murder case where my colleague also argued the appeal and made the same argument, and that was rejected by this court. Unless there's further questions, I'll take my seat.
So, Mr. Eanes, I do just want to briefly go back and revisit the gun issue. You made a bit of a production about the fact that Mr. Turner said he had a gun but never voluntarily turned it over. But just to be clear, he had no obligation to do that.
That's
It's
correct,
the
Your
state's
Honor.
burden. And even if he did have a .40 caliber pistol, there's probably, what, 1 million, 2 million, 3 million .40 caliber pistols in the state of Arkansas. I mean, it's the state's burden to tie those two things together. It's not Mr. Turner's burden
That's
or
correct, Your Honor.
obligation to provide that information for you.
Yes, Your Honor. One thing I think in diverting to the Snapchat earlier, and I have about 20 seconds, and I can't believe I missed this, but the elephant in the room, by the way, that's not been addressed in appellant's brief or in oral argument today, is that Mr. Turner, and I'm surprised, and I meant to start with this, is that Mr. Turner confessed. It's undisputed in that call to Roderick Shelby Sr., where Mr. Turner, perhaps to attempt to build an alibi or cover his tracks, made a condolence call in which he told Roderick Shelby Sr., asked him, "You shot the wrong guy. You know you shot the wrong guy, didn't you?" And Mr. Turner replied, "Yeah." I see my time is up.
Okay, rebuttal for the appellant.
So the state's focus on the evidence of Mr. Turner's callousness shows the lack of substantial evidence in this case. As this court knows, being callous is not evidence of guilt. You don't have to like Mr. Turner's actions here to find that there was insufficient evidence. The court has announced the standard for sufficient evidence of a circumstantial evidence case. As the court knows, that evidence has to exclude every other reasonable hypothesis. There were several here. That these 2 or 3 other guys shot and killed these 2 people on their own without assistance from Mr. Turner. The evidence showed that Mr. Roberson also had multiple phone calls with Mr. Shelby on the day of the charged act. The evidence showed Mr.
Mr.
Shelby...
Kaiser, would
Yes,
you
ma'am.
address counsel's, where he left off in saying that, well, Mr. Turner called Shelby Sr. and essentially confessed?
So I guess we have a difference of opinion as to what that testimony showed. Mr. Shelby Sr.'s testimony was a bit disjointed, and even if Mr. Turner acknowledged that the wrong guy got shot, it in no way shows that he was involved in doing it.
But just to be clear, it wasn't a statement, the wrong guy got shot. Wasn't it the statement by the victim's father, you shot the wrong guy?
I believe it was y'all or you. Yes, Your Honor.
So, I mean, that's, even if he had disjointed testimony, that's a much different animal than just saying the wrong guy got shot, so.
Yes, Your Honor.
But counsel, on appeal, we are looking at everything in the light most favorable to the state and upholding the jury verdict of guilt. So, we're taking sort of out everything else and just looking at everything favorable and then seeing if, it was reasonable for the jury to reach that verdict without speculating and whatnot. So in light of that, how do we overcome that?
Your Honor, I stand on the briefing with regard to that issue. With regard to the other evidence that Mr. Roberson reasonably did this on his own, Mr. Shelby had been robbed before, and there was evidence that Mr. Shelby had stolen Mr. Roberson's gun. The term accomplice does not encompass someone who is loosely connected to another person, someone who merely has guilty knowledge, someone who may be morally delinquent, or someone who might have even been an admitted participant in some other distinct crime. I think the state in their brief is arguing that my client was an accomplice after the fact, which, as this court knows, is a separate crime of hindering apprehension. Sufficient proof of that is not sufficient proof of capital murder. Even the knowledge that a crime is happening or is about to happen doesn't make someone an accomplice, nor does the concealment of knowledge or the failure to report it to law enforcement. And that is what my client is alleged to have done here. In terms of the jury and even the state's witnesses having to speculate to find guilt here, I think Detective Gibbons' testimony illustrated this perfectly. On record transcript, page 408, he testified, and then the phone calls match up between Kevon calling Joe Cortland and Kevon calling Roderick. And here's the important part, as if he is relaying information of where they're at. And I think that piece of testimony accurately represents the state's entire case. At every corner, each piece of evidence, you have to make a jump that the evidence doesn't actually allow you to make in order to find my client guilty. That was the state's entire case. Again, I believe I argued this in my initial portion, but the evidence regarding the Snapchat message was not cumulative. Witness tampering is not the same as refusing to turn over a gun to a police officer in any way, and it was incredibly damaging information. And then, yes, Pavlov, a seeming lay witness, non-expert, her testimony alone is what we went off the best evidence rule with Snapchat. But she acknowledged that she was not an expert on Snapchat in cross-examination, and she explicitly acknowledged she did not know if Snapchat could still provide access to that message, to those messages. And the citations in both the states and our briefing show they can. So we're asking this court to rule as the Court of Appeals did in Hopper v. Daniel, finding that a witness's testimony that they, I think, had given a hard copy letter to their lawyer a few decades prior was insufficient to show it was lost, destroyed, or unavailable. In conclusion, you don't have to like what Mr. Turner did do here or what he didn't do here. And you may have some belief that he was involved based on his association with everyone involved. But this does not change that the state failed to present sufficient circumstantial evidence and to exclude the very reasonable hypothesis that these three guys killed these two people without my client's involvement. Thank you so much. If there are no further questions, that's all I got.
Okay, thank you, counselors. That concludes our oral argument today. And will the bailiff please recess court?
All rise. This concludes today's oral argument. Thank you.